Awesome. Okay. Well, thank you so much, everyone, for joining us. Thank you for being here for the Alberta Liabilities Disclosure Project press conference around the strict conditions that the ALDP is urging the federal government to place on any loans for oil cleanup in light of the Alberta government passing Bill 12. My name is Christina Krasuski. I'm the regional organizer for the Prairies and Northwest Territories for the Council of Canadians, and I'm really appreciative of the opportunity to facilitate this space. Before we do begin, I just wanted to make a couple of housekeeping notes. So if you're able to keep your cameras off just for the duration of the formal remarks, that'll allow us to keep the focus on the speakers. And then following the formal remarks, we'll have time for questions. So if you'd like to get on the stack to ask a question, you can put an asterisk in the chat box. So if you want to turn your camera on for that question period at the end, that would also be great. I'm just gonna turn your camera off here, Bob. Perfect, just so we have spotlighted the folks that, that we're hearing from today. So today you're gonna hear from Regan Boychuk, ALDP lead researcher and oilfield liability expert, and Dwight Popowich, a landowner from Two Hills, Alberta, who has been personally impacted by the liabilities crisis. Dr. David Swan will also be on the call, so he won't be making remarks, but he will be available to take questions following the formal remarks. So I'll turn it over now to Regan.
Thank you. Good morning, everyone. Thanks for joining us virtually today. I'm Regan Boychuk, co-founder and lead researcher with the ALDP, a coalition of Alberta researchers, landowners like Dwight, farmers, professors, oil patch veterans, and former regulators. We truly are living through troubling times when we must drop everything to make sure people are healthy and taken care of. Unfortunately, the Alberta government isn't letting these crises be wasted. We should know by now to expect the ambitious to reach for dollars and power while we're all disoriented. In a speech at an oil lobby event yesterday, the Premier told industry insiders that oilfield reclamation is no longer a private liability of oil companies, but a, quote, collective financial liability, unquote. Now he's showing us exactly what he means. Under the cover of COVID, the UCP rammed through, in just 3 days, Bill 12, which made troubling changes to Alberta's oil, gas, and pipeline legislation governing the Orphan Well Association's operations while no one was looking. The Orphan Well Association, but the ALDP noticed. The Orphan Well Association has always been deeply flawed. Its board is dominated by industry, and it regularly misinforms Albertans about the cost of cleanup, and generally gives a false sense of security in the face of Alberta's crisis and unfunded oilfield cleanup. It's not well known, but by law, Alberta's energy regulator must charge industry enough to cover the full cost of cleaning up its entire orphan inventory every year. The OWA shouldn't have any unfunded wells and should never need a public bailout at all. Yet it relies on an alarming pattern of public loans to get cleanup going, when companies that dined on profits are increasingly dashing on their cleanup bill. They're breaking the law, and Alberta's government is letting them. Worse, with Bill 12, the Alberta government used the cover of COVID-19 to make the OWA even worse. At the very moment the federal government, that's Canadian taxpayers across the country, are about to put Albertans back to work with a loan to the OWA. Bill 12 is 30 pages of amendments to hundreds of pages of legislation and regulations. The implications of Bill 12 are far from fully fathomed, but there are 4 parts of it that the LDP finds particularly concerning. Number 1, it threatens landowner rights by broadening the list of activities companies can carry out on private property without compensation to or consent from the landowner. Bill 12 also politicizes cleanup by giving cabinet power to direct the OWA's work and funding. Instead of science and data guiding cleanup, such as prioritizing the most dangerous wells or those closest to water aquifers, cleanup decisions are now in the hands of politicians. This gave cabinet unprecedented powers and public dollars to win favors and shun opponents. I'm sure Canadians don't want their tax dollars to become a slush fund for the Premier Kenney to reward his friends and punish local community advocates. Third, Bill 12 undermines compensation for landowners by allowing the OWA to take over assets of bankrupt companies, continue operating their wells, and then conduct cleanup, circumventing existing right of entry law. Finally, Bill 12 incentivizes the offloading of wells to the OWA by transferring landowner compensation to taxpayers, while unpaid property taxes to municipalities will get written off in bankruptcy. In light of these troubling changes that are now law today, the Alberta Liabilities Disclosure Project is calling on the federal government to place strict conditions on any public loans to the Orphan Well Association to avoid political influence, uphold Canada's polluter pays principle, and create prosperity and employment rather than lining broke industry executives' pockets. Those conditions are, first, to require the Orphan Well Association to collect full, legally required levy every year. By law, OWA should be collecting enough levy from industry to cover the cost of cleanup of all orphans every year. It doesn't. That could very well have meant $1 billion more for cleanup work and good jobs this year alone. Allowing the OWA AER not to collect the full amount that's legally mandated is an indirect oil patch subsidy and is leading to a troubling pattern of relying on public dollars to finance industry cleanup. The federal government must require Alberta to follow its own law before lending the OWA a single penny. Second condition is that any loan to the Orphan Well Association should include a short timeline for repayment. ALDP urges a 3-year timeline to minimize interest costs and the risk of default. Any write-off scenario for a federal loan would again be another public subsidy to industry, undermining the polluter pays principle, and must be avoided. Third, any loan to the OWA should be matched with a direct investment in building Indigenous capacity. A federal loan to the OWA should be matched by at least $30 million to fund an Indigenous steering committee focused on education and training to launch Indigenous-owned enterprises to lead cleanup work. In this way, the OWA loan can become a vehicle to advance Indigenous entrepreneurship and UNDRIP principles. Fourth, the federal government should finance landowners to reclaim well sites on their own land. If we set aside $30 million for landowners to hire contractors to clean up well sites on their land when the industry won't do it, the bill can be sent to industry. The Supreme Court has confirmed it, and the federal government could facilitate that work with a fund helping landowners. And fifth, we're calling for independent oversight of federal funds. The UCP Cabinet's grasp for control of the OWA could be neutralized by an independent body of experts and consultations to determine how to best prioritize cleanup with federal dollars. One focus should be on orphan wells with unpaid rural taxes and unpaid landowner compensation, so that those debts can be paid through the orphan levy rather than by taxpayers, as is currently done. The federal loan could also include stipulations in ensuring that landowners are properly notified and compensated at all sites cleaned up with federal funding. Now let's return to Bill 12, introduced on the afternoon of March 31st and passed the morning of April 2nd. Bill 12 came about because of questions ALDP members were asking about the OWA and whether they had the proper service rights to carry out cleanup. The OWA denied they were trespassing, but then went to the Alberta Energy asking for legislative changes that grant them authority to continue operating on private land without landowner consent or right of entry order. Not compensating landowners will save OWA money, the same way money could be saved by dumping toxic waste in schoolyards instead of at licensed disposal facilities. And just as federal taxpayers were about to extend aid to Alberta's unemployed oilfield workers through the OWA, Bill 12 grants the United Conservative Party cabinet power to direct cleanup work and funding. This era of misplaced generosity, where we pay for the oil patch's tax cuts and bailouts, must end. Dining on the profits of our public resources, then dashing on your bills and dues to the community, isn't a business model worth saving in this crisis. Albertans must demand better. Thanks.
Awesome. Thank you so much, Regan. And now we will hear from Dwight.
Good morning. My name is Dwight Popowich, and I have an orphan natural gas well on my land near Two Hills, which is 100 kilometers east of Edmonton. It was drilled in 2008 and stopped producing in 2012. I was paid $2,500 a year in lease payment as well as sitting on my land. Now let's be clear, it's not an orphan well. We know exactly who Bub and Dad are. It's that being Sequoia Resources Corp. Sequoia stopped operating in March 2018 and walked away from cleaning up the well. It's in the middle of my field and we have to work around it. I don't have use and it's been taken away from me. It's not a lease anymore, it's forced expropriation. Farmers and landowners across Alberta elected oil and gas companies to clean up the wells on our lands once they stop producing. But many energy companies have betrayed Albertans and ditched their duties to themselves. Now, the government of Alberta rammed through a disturbing new law in just 3 days during a global COVID-19 pandemic. Further erodes our rights instead of fixing a broken system. In short, the changes from Bill 12 are a disaster for farmers and landowners with oil and gas leases. Bill 12 gives Alberta's Orphan Well Association the right to operate still profitable wells on our lands without paying annual compensation to us. Worse, the reasons a company or the Orphan Well Association can now enter our lands without consent or a Surface Rights Board order has been significantly expanded. This was done without consulting us or our associations. Landowners have rights that must be observed, but this government is abusing them. Bill 12 is an erosion of our rights as surface owners. Let me explain how. First, Bill 12 is all about legalizing trespass on our lands by the Orphan Well Association. Until now, a company or the Orphan Well could come onto private property without consent for emergencies or very specific tasks. For example, when a person needs to carry out work of an emergency nature and may not be able to locate the landowner, or when it's impractical for public safety to seek a landowner's consent, negotiate an agreement, or apply for a right of entry order, an immediate entry is required. Once Bill 12 became law on April 2nd, an operator can now do much more without seeking our consent as landowners, who are the owners of the surface rights. Now, a person can engage in land remediation activities without seeking our consent. Now, a person can engage in land reclamation activities without seeking our consent. And now, a person can even engage in new activities related to impairment of or damage, which is a new term for the first time in Bill 12, without our consent. Some of the implications of Bill 12, for decades, our consent or a right of entry order was required to do anything on our land except decommission a pipeline or abandon a well or pipeline. Post Bill 12, a person can now conduct almost any activity on our land, even by trespass, other than drill a well, construct a facility, or construct a pipeline without our consent or a right of entry. We deserve far better from our lawmakers. How can we tell the world we are environmentally and ethically responsible in developing our energy? This is happening in our backyards. It's a joke. It's a lie. Our system is broken, and this law makes it worse. If the federal government gives any money to the Orphan Well Association with the new powers it now has, they will help erode landowners' rights, weaken regulatory oversight and undermine Canada's polluter pays principle. We can't have that. Anyone with existing well, facility, or pipeline on their property should be concerned by Alberta's changes and about a federal loan to the Orphan Well Association without any strings attached. We need strong conditions on any to protect our rights and make sure industry pays for their cleanup. Otherwise, it'll be a blank check to the UCP government to erode our rights and bail out dine and down companies while we, the public, get stuck paying for it. Thank you.
Thank you very much, Dwight. So now we have time for questions. So if you're able to to turn your cameras on now. If you are interested in asking a question, I'd ask that you put an asterisk in the chat box so we can develop a question list that way. And if you're having any issues with getting off of mute or turning your video on, just let me know. If you're on the phone as well, if you just want to pipe up, we can add you to the speakers list that way.
Okay. Is this audio working?
Yes. Hi, Bob.
Hi. Okay, good.
Oh, yep. And then we'll go to the phones after Bob's question. Go ahead, Bob.
Oh, okay. Um, for a long time, the people have pointed out the main problems with the Alberta's OWA regime is that there are no timelines for cleanup and that there's no upfront surety. I'm wondering if you folks see anything in this legislation that will fix those two holes that have been pointed to for years.
From our reading, there certainly isn't anything that plugs those holes. One of the things that we were concerned about, and though while it is true Alberta doesn't have timelines for reclamation, there are all sorts of legally mandated situations where the plugging, the permanent closure of the well is mandatory. And we were concerned that that would be one of the targets of these reforms. They're not in Bill 12, but there's also a range of other legislation and changes coming. There's all the rules and regulations that are going to implement Bill 12 that are going to be determined by Cabinet. And there's Bill 7 is going to amend the RETA Act, and the LLR program is being canceled and replaced. So there's a lot of changes coming. When it comes to upfront deposits, there's nothing of that sort in Bill 12. And to a certain extent, so many horses have left the barn. It's a little bit late for that being a main response. We drill so few wells yet today, and there's so many we've already accumulated that even upfront bonding would be a very, very limited solution. But we'll have to wait and see all the other puzzle pieces of coming reforms.
Great, thank you, Regan. I'm going to unmute. We have a call-in user who was trying to speak earlier, so if you have a question, now is your time.
Hi there. Yes, I have a question. First off, I'm wondering how many orphan wells are there, like in Alberta right now? And I would like to talk about also compensation. Are you saying that now you won't be getting money or compensation from if the companies are doing work on your land? Is that what you're saying? I just want to make sure.
What happens when wells get transferred to the Orphan Well Association is the licenses get terminated and compensation shifts to the Surface Rights Board, who pays landowners when industry is no longer able. And so the way that it currently works is that taxpayers pay landowners for the annual compensation on orphaned infrastructure. And if these new changes in Bill 12 are going to incentivize and accelerate transfers to the OWA, it's just going to increase the number of wells that have their annual compensation paid by taxpayers instead of industry. And that's one of the things we'd like to guard against.
And sorry, just to verify, which news outlet are you with?
Oh, I'm with Radio-Canada, the French CBC.
Perfect, thank you.
Yes. And I also have one last question. What kind of conditions are you asking from the federal government?
I walked through them briefly in my statement. They'll be in the media release, detailed. But the gist of it is that any loan to the OWA should be short-term, and it should be balanced with supports for other stakeholders like landowners and First Nations, and to help ensure that it doesn't further undermine the polluter pays principle.
Thank you.
Thank you.
Perfect. If you have any other questions, you can throw an asterisk in the chat box, or if you are on the phone, if you want to unmute yourself. And just a reminder, we also have Dr. David Swan here as well, who is a member of the ALDP, who is willing to answer questions.
Not entirely sure how I throw an asterisk in the
All
chat
good.
box.
Go ahead, Bob.
Okay. The question for Mr. Popowich. You were talking about being unhappy about the OWA now having the right to come on your property and perform do remediation actions. And I guess my question is, why is that a problem for you? I mean, if they're coming on your property to clean things up, why is that a bad thing for you?
Well, we really don't have a problem with them coming on our land to clean it up. What we have a problem with, come on our land without talking to us about it. What these changes are doing now is it's going to allow the Orphan Well Association to actually produce from these wells. And when these wells are producing, we as landowners should be getting paid our annual compensation for these wells sitting on our lands. And what this will do is it'll allow the Orphan Well Association to produce these wells, or to operate them as producing wells, and not pay us, which is totally wrong. I have no problem, and I don't think any landowner has a problem if you have an orphan well on your land, of them coming on and taking care of it, remediating, and doing all the necessary things that clean it up. But if they're going to come on our land and starting to produce just like a normal operator, then we expect to treat them like operators, which means you will have to be paying us, which any other operator would be paying the annual leases.
Thank you, Dwight. We have a question that was brought up a little earlier. Mark Doran brought it again in the chat box. The number of orphans at present.
That's a little bit unclear. Some of the recent numbers was that there's about 3,500 orphan wells. That's a rounding error when it comes to the crisis of unfunded cleanup. There's about 300,000 wells to clean up. Orphans are a small portion. They also have, it's either dozens or hundreds of facilities, and they have thousands of pipeline segments in their inventory. So they were saying about 3,500 recently, and they just set 2020's budget based on that. But in public presentations since, that number has shot up to closer to 6,000. So it's a little unclear, but we are still talking about a small portion of the overall problem. And in some sense, we're focusing too much on the small batch, but to try to clarify how many there are, it looks like something like 6,000 wells.
Awesome, thank you. If you have any other questions, if you can figure out how to put a star in the chat box, that would be great. Otherwise, if you want to come off mute and ask your question.
Hi there. I also have another question. I'm just wondering if you brought your concerns to the UCP or the federal government, and what were their answers?
Thank you.
Yeah, we have reached out to the new UCP government. We did so as soon as they were elected, and we have had numerous conversations over the last year with Alberta Energy. We haven't been able to get meetings with the energy regulator, the energy minister, but we've reached out to them, and it's more the federal government that will determine the character of this, much of the cleanup with this coming loan. And so that's where our attention has been focused. We haven't had a lot of willingness to chat about these issues with Alberta's government.
Great, thank you. We have a question from Barb Glenn in the chat box. Could you further elaborate on any recourse that rural municipalities might have with regard to unpaid taxes from energy companies?
Sure. There's a couple of self-help strategies that ALDP has been working on and plan to do some more work informing landowners about what they can do. One of them is that most leases in Alberta, when the oil and gas operator on your land doesn't pay his rural taxes, most of those leases can be terminated by the landowner. They can put the ball back in industry's court. They can share the inconvenience with industry by blocking their access to the site and forcing them to go back to the Surface Rights Board to negotiate re-entry. And we'll be developing some more solutions and strategies in the near future. But these, particularly the changes in Bill 12, should raise very serious concerns for any landowner considering signing any new lease. They should be taking it to the Surface Rights Board for arbitration in the quasi-judicial form before the board to sort out all the complexities that were introduced by these amendments and some of the long-standing issues. And so we hope to continue doing that work to help educate landowners about what their options are and how they can pursue them.
Maybe we'll move to Bob Weber now. I don't know if you want to ask your question, Bob, or I can read it.
You can read it, that's fine.
Perfect. Can you expand on why you think the Alberta government is using the COVID crisis to make these changes?
Yeah, I think that's a pretty fair interpretation of introducing 30 pages of amendments without consultation during the emergency session of the legislature, and conducting 3 readings and royal assent within a few days. This has very little to do with COVID. It is an alarming expansion of cabinet and Orphan Well Association powers. And the opposition raised some very valid questions about why this is happening now, why this is being ran through an emergency session without debate. It wasn't possible for landowners, let alone opposition politicians, to digest, analyze, let alone meaningfully respond in 3 days. So one has to assume that was the objective.
Thank you, Regan. Would you be able to expand a little bit on the condition that Barb brought up around loan paying back taxes?
Sure. The ALDP held a workshop a month or 2 ago in Didsbury, kind of starting to explore this option that even in the standard industry form lease agreement that is landowners often sign just by filling in the blanks of this formed legal contract. Even in that model contract, it includes a clause that says if rural taxes aren't paid, the landowner may terminate the lease. And so there's an enormous problem in Alberta with unpaid rural taxes. Hundreds of millions of dollars are not being paid to rural communities, most of them by companies that are still active. The industry is on a tax strike, and the municipalities are at a loss. They're not allowed to run a deficit, so they have to raise taxes or cut services immediately, and they are asking for additional powers. They don't have the power to get this money out of industry, but landowners can help them. In any one of these sites where they haven't paid taxes, the landowner can send a letter giving 30 days notice, asking the operator to please prove they are up to date on all of their taxes. And if they're not, the lease will be terminated. The gate will be locked, and the operator will have to return to the Service Rights Board to renegotiate entry. And it's a way to put the ball back into the court and to share the enormous inconvenience that landowners are being saddled with.
So we have time for one more question. If anyone would like to pose anything to Regan, Dwight, or again, Dr. David Swan is on the line.
May I, a quick question?
Sure, go ahead.
Is there any possible legal recourse here?
It depends who you're speaking of. First Nations have the constitutional authority to regulate oil and gas on their own lands, however they see fit. And so they could change the rules to fix these loopholes and to protect themselves against the risk they face of inheriting these liabilities. When it comes to landowners, the Supreme Court has said that they can carry out the cleanup work. If the well's been plugged, they can clean up the site and send the company the bill. That's entirely possible. And as far as municipalities go, trying to collect their back taxes, they've said that the cost and complexity of trying to pursue this legally just doesn't justify the effort of individual municipalities. And so our work is continuing on the sort of legal self-help options that are available to the different stakeholders, and our work will carry on trying to elaborate and add to those options.
Awesome, thank you. So we are just about at time. I know Barb has snuck one more question into the chat box, so I'll let Regan respond to that, and then we will close for today. So Barb is asking, has any federal or provincial money been announced and specifically earmarked for use by the OWA at this point?
Thanks, Barb. That's a good point for me to close on. And so it's been obvious for a few weeks that the federal government is considering to put Albertans back to work in the oil patch, and the provincial government has been lobbying to shape that, and nothing has been announced yet, but it's widely expected that loans to the Orphan Well Association will be part of that package. And the reason we're highlighting that today, even though it hasn't happened yet, is because Bill 12 makes that more problematic, and we want to alert federal taxpayers to some of those risks. And there's one more of our strings that we say should be attached. One of the things that can help some of these other affected stakeholders is that any federal money should prioritize those sites that have unpaid landowners and unpaid taxes on them. And instead of those debts being transferred to taxpayers, as we do now, they should be added to the list of costs to be paid by the Orphan Fund. And that's one way we can make sure the polluter pays instead of taxpayers.
Awesome. Thank you again, Regan. Thank you again, Dwight. Thank you, Dr. David Swan, for being on the line. And thank you, everyone who was able to join today. We'll be following up shortly. Actually, I think the press release has already been sent to you. If you do have any further questions, they can be directed to Regan. And otherwise, have a wonderful rest of your day. And thank you again for joining us.
Thank you.
Thank you. Take care.